Good afternoon to everyone present here. I think it's a very tough act to follow. Monica was too eloquent and I really doubt whether I can maintain the momentum. I'll try to do my best. In fact, today there is a conference in Supreme Court. The Supreme Court of India and Supreme Court of Singapore have organized a conference on law and technology. Chief Justice Chandrachud is presiding over, and I was one of the 5 judges nominated by the Madras High Court Chief Justice to be present in Delhi. I wrote a letter to my chief. Chief, I have been asked to be present in Government Law College, Mumbai today, and therefore, please grant me leave of absence. And that's why I'm here. Friends, I would like to introduce a name or two during the course of my presentation. One name that I want to introduce now is Raja Rao. I do not know how many of you have heard of that name. He was one of the earliest writers in English, Indian writer in English. Kantapura was one of his well-known novels. It was written sometime in late 1930s. More than the novel, the foreword became, it acquired a cult status. There Raja Rao says, see, English has become a part of our language. And why should we imitate or ape the Englishman? We will speak English in our own way. We have our own accent, our own writing style. So that foreword is too important, and I request you to read that foreword. But what attracted me in that foreword was, Rajara would say, this whole India is a sacred geography. You go to any village, anywhere in India, they will associate their little place, that maybe the tank or that even the tree, with something with their Itihasa, with Ramayana and Mahabharata. They will say, Sitama took bath in this tank, Rama took rest under the tree, like that. So this sacred space, it's very, very important. Friends, I had a similar feel when I entered this campus. This is the first time I am entering this Government Law College. And Principal ma'am spoke about it. Monica ji said, see, Dr. Ambedkar had studied here. Nani Palkiwala, Jethmalani, name it. How many legends have? So you will be sitting on some bench or chair where once those legends sat. So therefore, when I entered this campus, I remembered the sacred space concept which I read in Kantapura. I am grateful to Bharat Gopuji, Shyamji and our principal ma'am for inviting me here to stand before you. I am truly grateful, truly grateful. See, whenever I get to meet the students, I invariably give them a reading list. But today I am not going to give you any list. I will mention only one author's name, P. Ramanatha Iyer. He was born in early part of the 20th century. You would have seen his advanced law lexicon. But I recommend to the students to go to his Art of Advocacy series. Wonderful, full of anecdotes from the masters in law. His granddaughter presented me the second volume of that book a few days ago. The book was very old and it was published by Vadhva from Nagpur. See, it's so unfortunate, na? Tripathi is not there, Vadhva is not there. So, okay, let me come back to Ramanatha Iyer. It was a very old book, published sometime in 1956 or so. The pages were brittle. And I was slowly turning over the pages. And in one page, I think page 124, I came across the name Alexander the Great. I was immediately arrested there. It was a quote from Donovan's Modern Jury Trials. It says like this: Alexander had successfully taken a city, he was in his military campaign, and somebody asks him, "Sir, if given opportunity, will you take the next city also?" That was the question to Alexander. Alexander thundered, "Opportunity? What opportunity? I make opportunities." That was what Alexander said. Why I refer to this episode, anecdote found in Ramanatha Ayer's Art of Advocacy series? See, whenever the topic of implementation of Uniform Civil Code comes, invariably the response of the critics is that time is not opportune. That is what they say. Friends, next time when somebody says this, our response should be Alexandrian. We make opportunities. That should be our response. In fact, such a response was given by the Supreme Court in Shabanu's case. Monica ji referred to that judgment at length. I request every law student here to go to that judgment and read it in full. Full judgment you must read. Justice Chandrachud, the father of the present CG of India, he was also CG of India. He thundered in the judgment. Article 44 has remained a dead letter. He says, don't expect the Muslim community to take the initiative. No community leader will bell the cat. Initiative or no initiative, state must act. That was the mandate which the Supreme Court, that was the nudging which the Supreme Court gave in the judgment. Friends, in fact, the phrase justice to all, you will find in those concluding paragraphs in the judgment. That justice to all is expressly found in those paragraphs. Appeasement of none, you will be able to infer in those paragraphs also. Friends, this Chandrachud, this judgment, it created a huge controversy about which Monica ji referred. But friends, now I am going to refer to three specific cases. The first one which I decided. See, when a judge is hearing a matter, he would like to align his results with the justice. But we are only courts of law. We are not courts of justice. We have to decide as per law. And that produces an inner struggle. Some 2 years ago, one case came before me. When Haba Bibi and Muhammad Sultan, they got married. They had 3 sons. Out of them, 2 died, 2 predeceased the parents. So this good old Muslim lady wanted to make equal provision for all her 3 sons. 1/3, 1/3, 1/3. That is how she executed the will. But then the living son alone was in occupation of the house. The other 2 were outside. So the grandchildren of the deceased son, they filed a partition suit. Do you know what was the defense taken by the living son? He said, you could have executed a will only for 1/3 of the estate, not for the entire estate. There's a bar in the Muslim law. Forget that even. Muslim law says the sons, the children of the predeceased son are not legal heirs at all. They cannot have any claim on the estate. That's what the Muslim law says. And he was quoting from Mullah's Muhammad Allah. I just couldn't say anything. With great legal jugglery, I was able to somehow do it and ensure that justice was done to the grandchildren also. And they upheld the will of that old Muslim lady, the good old lady. Why I am referring to this? The lawyer, he can talk anything and walk away. But the judge can't do that. A couple civil can talk anything and walk away. Why I am referring to couple civil in particular? For certain reasons. Not because the fee is scheduled, not because of that, which you read in bar and bench. Not because of that. Because 2 years ago, at a book release function, I said, we have a great constitution, secular constitution. This constitution, if it has to remain for all times to come, then the religious demographic profile which originally existed should also remain intact. The status quo should remain intact. If the demographic ratio is terribly altered, then this constitution will perish. That is what I said in the speech. And the next day, Kapil Sibal gave a very harsh tweet condemning me on my mindset. So, see, ma'am was talking about judges and lawyers and all. We also have our own petty egos. And to settle my petty ego, only I am dragging in Kapil Sibal. No other reason. But the point is, as a judge, I would like to, align my results with justice. And personal loss can be a huge, insurmountable obstacle in rendering justice. And that is why, only to overcome that, we are saying there should be uniform civil code. Ma'am was talking about Shabanu case, and immediately thereafter, there was another case. Jordan Diengde versus SS Chopra. My young friends, please make a note of it. Jordan, J-O-R-D-E-N, Jordan Diengde versus SS Chopra. Very important judgment. See, this lady was a tribal Christian from Northeast. She was an IFS officer. She got married to a Sardarji. It was a church wedding. Then they couldn't get along and they wanted to part ways. But then, since it was a church wedding, it is the Christian law of divorce, Indian Divorce Act that would apply. And during middle 80s, the law had not been amended as now. So that was actually next to impossible to get a divorce. So the matter goes to Supreme Court, and Chinnappa Reddy, while issuing notice in that case, gave a very beautiful, brilliant opinion. He said, this is a very unsatisfactory state of affairs, and this is only because Uniform Civil Code has not been implemented. He compared the Christian law, the Hindu law, the Mohammedan law, everything, and said it's time we do something about it. Why I am specifically quoting this judgment and why I am mentioning the name of O. Chinnappa Reddy? There is a reason. O. Chinnappa Reddy, he is a Christian by birth, but he was a Marxist and he is a darling of the left liberal group. And it was he who authored that national anthem judgment also, Vijay Emmanuel. So this name Chinnappa Reddy is a very, very, it's a very sweet name to those who are opposing Uniform Civil Code. And to them, I suggest we cite this opinion of Chinnappa Reddy. See, we must make use of this Shikandi character coming in Mahabharata. See, when Shikandi is there, Bhishma cannot throw arrows. And in fact, Arjuna was not hiding behind Shikandi, he was standing behind Shikandi. And therefore, I am saying, we must use Chinnappa Reddy as our Shikandi. Whenever we must say, it is Chinnappa Reddy who said this, we must keep saying this. This is the second judgment which I want you to read in. The third one is, again, which came sometime in 2015. A Christian lady, she was an unwed mother. She begets a child, and the father does not want to come out into the open. And she wanted to be appointed as the guardian for the child. And Christian personal law did not permit it. Again, the matter goes to Supreme Court, and the Vikram just said, gave again a very scathing judgment, very strong judgment, saying we must bring in Uniform Civil Code. See, Monica ji was telling that whenever the helpless women went to the Supreme Court, invariably, almost in all cases, Supreme Court gave justice to all the women. In all the cases. And in fact, I can tell you, go to any case, Supreme Court will invariably be upholding the importance of bringing in this Uniform Civil Code. See, it's not a question of mere rhetoric alone. See, now this is a serious discussion. We have to answer the queries raised by the critics also. I will take up only one or two alone. One major objection raised by the critics is our fundamental right guaranteed under Article 25 and 26 are violated. In fact, I was reading one article very recently. There the learned author says, marriage is something very intimate, very personal. I get married as per my religious rights and customs. And in India, we have got a plurality of religions. So how can there be uniform marriage law? Will it not be an imposition? Will it not violate your fundamental right? That is how they are posing questions. Friends, there is a simple, straightforward answer. John Vallamatam, I think it is 2003 and 2004 Supreme Court. It's a case which arose from Kerala when Christian priest challenged the constitutional validity of Section 118 of the Succession Act, which put ceiling on the biggest charity a dying man can make in his will. And Supreme Court struck down, 3 judges bench, it struck down that Section 118. While so striking down, the Supreme Court said, friends, please note down, very, very important. They said, marriage, inheritance, succession, these things are pure civil laws and they have nothing to do with religion. Supreme Court has said. Not once, in several cases they have said. In fact, they even said, you can't even invoke Article 25 or 26. Legislation cannot come within the ambit of these provisions. And if it comes, they are suspect legislation. That is what Supreme Court says. So the most important point in John Vallamatam case is, if anybody says my fundamental right in 25 is violated, sorry boss, Supreme Court has already said you can invoke 25. In fact, they went to further extent. They said, in a civilized society, there is no connection between personal law and religion. That is what they say. And I think we can say to the critics of UCC, you are an uncivilized lot. I think we can say that also. In fact, that's what Supreme Court says. If somebody says I am using a very defamatory language, I will use Supreme Court as my shikandi. It's not my language. So Supreme Court has said, in a civilized society, there is no connection between personal law and religion. Friends, another homework that I would like to use is, see, in Constituent Assembly debates, it will run to hardly 30 to 35 pages and not more than that. I request the Constitution Club members to circulate all the speeches in this CAD among all the students here. It will not, you can finish the entire thing in less than 2 to 3 hours. You must read the speeches of Alladi Krishnaswamy Iyer, you must read the speech of K.M. Munshi, and of course the great Dr. Ambedkar. In fact, the Muslim members very strongly opposed, but these 3 stalwarts so effectively countered every objection raised by the Muslim members. They said, we have just now got divided on the base of religion, and therefore we must do everything that will make us a single united nation. They said this uniform civil code will help in that process. In fact, Dr. Ambedkar said, again, Monica ji was while tracing the historical developments, was telling all that. In every other branch of law, we are having uniformity, criminal laws, even transfer of property, NI Act, so many acts. And Ambedkar used one beautiful expression, please remember this also. He said, there is only a little corner that has to be made uniform. That's the word he used, little corner. He said in every other aspect it has become uniform. It's small, marriage, succession, maintenance, adoption, that's all, nothing else. Everything else we are having a common civil law. So in fact, he said, the government can bring in a uniform civil code. It can be made optional at the beginning, then it can become binding on everybody. That was a suggestion which Ambedkar said. Who should have carried out this suggestion? Who should have implemented this suggestion? I would fault one man, and that is Pandit Jawaharlal Nehru. In fact, I am not saying it. Madhav Godbole, a very erudite civil servant, in his biography, God That Failed, he says, Jawaharlal Nehru did not want to displease the Muslims, and therefore he committed default, and that is why he failed to implement this suggestion given by Ambedkar. So the one man who is to be squarely blamed for this is only Pandit Jawaharlal Nehru. But that is history. We can't still be talking about the same thing. We have to move on to the current times. Friends, ma'am was talking to you about one judgment. What was the judgment? Please repeat. Narasu Appamali versus State of Bombay. 1952 Bombay High Court judgment by division bench of Muhammad Karim Chagla and Justice Gajendra Khatkar. Two most eminent judges we ever had. Most eminent judges. And I request every one of you to read Justice Chagla's Roses in December. All of you must read that book. In fact, I would have read it 100 times. It will inspire you like anything. Then Gajendra Katkar's To the Best of My Memory, published by Bharati Vidya Bhavan, if I'm not wrong. Again, another. Of course, it is not having the prose standard of Chagla, but still it's a very inspiring book. Very eminent judges, but both of them wrongly held that personal law will not fall within the scope of Article 13. See, this is another homework I am giving you for one reason. See, whenever recently Tamil Hindu had come out with a small booklet containing both viewpoints, for and against, and quite a few authors who are opposed to Uniform Civil Code, they had quoted the Law Commission report given in the year 2018. This is Chauhan's report. See, there, Mr. Chauhan has said, Uniform Civil Code is neither necessary nor desirable at present. That is what he has said. Everybody is quoting this. And I was going through that entire report. Friends, in fact, when the government, made the reference to the Law Commission, do you know what was the reference? To examine matters in connection with the implementation of Uniform Civil Code. That was the reference given to the Law Commission. But what Law Commission said? It came out with a consultation paper on family law reform. That is how it came. Unfortunate. And I was going to the report, and the eminent members were under the impression that the proposition laid down in Narasu Appa Mali had not been undone so far. That is the basic premise on which the entire report is resting. Friends, and I request all of you to go through the march of law and satisfy yourself that the proposition laid down in Narasu Appa Mali had been buried 100 fathoms deep in Arabian Sea. I can definitely tell you. See, so case after case, Supreme Court has struck down the customs, the personal laws that are opposed to fundamental rights. What is this? A triple talaq judgment? What is Savarala judgment? If the court came to the conclusion that something is contrary to the Part 3 of the Constitution, it had to go. But still, in this report, the authors are under the impression that Narasu Appa Mali is still holding the field. For I request all of you to undertake a serious study of that also. Friends, I am coming to my conclusion. I have only one request to make to all of you. Our country, our nation was partitioned, vivisected in the name of religion. Those who sought a separate nation went away. And those who remained, they remained here only in their capacity as Indians. All of us, everybody who remained are Indians. Where the question of course, in any civilized society, the rights of minorities will have to be protected, no dispute about it. But now I want to give a thought to all of you. Please consider. I would suggest that rights of minorities means minorities of weak, vulnerable minorities. I will make a distinction between chota minorities and bada minorities. Will you agree? Yes. If the minorities are too strong, see for instance, take Kanyakumari. I come from Tamil Nadu. In Kanyakumari, Hindus are in a minority. They are not in a majority. And what minority tribes we are talking about? So therefore, these are all subjects on which we should be really expending our thoughts. And I am truly delighted that Constitution Club and Indoi Analytics have organized this beautiful program. And I would see, whenever any war takes place, any battle takes place, the captain gives a command, take position. That will be the command. And we are now facing an ideological war, and we must take positions. And when it comes to Uniform Civil Code, we must say the time has come to activate Article 44 of the Constitution of India. Thank you.